Ben, could you bring me a drink? There's one that's partially open on the bottom of the fridge. Thank you. All right, we're on record. All right, are you Arnell S. Johnson?
C. Johnson,
Charles,
yes, sir.
I'm sorry, not S, C. Charles?
You're fine, yes, sir.
Yeah, there's a misprint on the jacket.
Does that get me out for free?
All right. Case number 22 CR 167, 22 CR 147, both styled State of Ohio versus Arnell Charles Johnson. Mr. Johnson is appearing by Zoom from the jail. His attorney is Jacob Wagner, appearing from his office. Appearing from the prosecutor's office is Adam King, assistant prosecuting attorney. This matter was set for a hearing to request the parties, indicating that they had reached a resolution of these two cases. And in case number 22-CR-147, Mr. Johnson is charged with aggravated possession of methamphetamine. And in case number 22-CR-167, he's charged with grand theft of a motor vehicle. Now, Mr. Johnson, I've been presented with a plea of guilty form in 22-CR-167 and also in 22-CR-147. These are plea of guilty forms. Oh, before we go any further, Mr. Wagner, you and your client are both in agreement this matter can be conducted by Zoom rather than defendant appearing in person in court?
We are, sir. We talked about this morning.
All right, you're all right with that, Mr. Johnson?
Yes, sir.
All right. Yeah, Mr. Johnson, any time during this hearing, if you would like to speak with your attorney privately, tell me, and I can put you and him into a breakout room. I think we may have done that the other day for you, didn't we?
Yes, sir.
I knew we did it for somebody, and I was thinking it was you. And then the two of you can talk privately without anyone else, hearing or listening. And the deputy will leave the room while that's happening. Okay. Now, I've been presented with two plea forms here, Mr. Johnson, both styled State of Ohio versus Arnell Charles Johnson. I'll hold up the first one, case number 22-CR-147 to the camera, and you see that your name and that plea of guilty form there and the case number?
Yes, sir.
All right, and then 22-CR-167, I'll hold up the camera, and you see those, that one as well?
Yes, sir.
Okay. Each of these documents are 3 pages in length, and on page 3, on both, about a third of the way down, there's a sentence that reads, "I enter this plea voluntarily." And below that, there's a signature. It looks like Arnell Johnson to me, but I'll hold this up. This is 147. I'll hold up to the camera and ask you if that is your signature right below that sentence that says, "I enter this plea voluntarily." Okay? Then on 167, I'll hold it up and ask you the same question. Is that your signature?
Yes, sir.
When did you sign these agreements, Mr. Johnson?
Earlier today, sir.
All right. Did your attorney go over these with you and explain them to you and answer any questions you had about them?
Yes, sir, he did.
And when you signed them, did you understand that they were agreements to plead guilty, which means there won't be a trial, and the next step in your case would be a sentencing hearing?
Yes, sir.
And do you feel you had enough time to fully consider the matter before agreeing to these agreements and signing them?
I do, sir.
And you still want to go forward with these agreements this afternoon?
Yes, I do. Yes, sir.
Did you enter into both of these agreements voluntarily?
Yes, sir, I did.
All right, now, page 1 of each agreement sets forth a charge. Case number 22-CR-147 says you're going to plead guilty to aggravated possession of methamphetamine under 2925.11 of the Ohio Revised Code, 5th-degree felony. States that you understand that the maximum penalty for that, if convicted, could be 12 months in prison. Minimum would be 6 if there's a prison term imposed. There could be a fine of up to $2,500 and a possible license suspension of 6 months to 5 years. Now, the agreement of 22-CR-167 is grand theft of motor vehicle under 2913.02A1, a 4th-degree felony. States that you understand the maximum prison term for that, if convicted, is 18 months. The minimum on that is 6 months as well, if prison is imposed. There's also a fine available of up to $5,000. There's an error on that form. It says there's a license suspension of 6 months to 5 years. That was cut and paste, I'm sure, from the other one. That's not applicable, so I'll strike it out. Now, you understand that?
I do, sir.
Now, under the law, Mr. Johnson, if you are convicted of both offenses and if you should be sentenced to prison, sentences could be ordered to be served consecutively, meaning one after the other, which means total could be 30 months in prison, fine of $7,500 for the two charges. Do you understand that?
I do, sir.
Are you facing any other felony charges in any other jurisdiction at this time?
No, Your Honor.
And are you currently on probation, community control, parole, or post-release control for a felony?
No, sir.
Right now, you have, under the law, to understand the maximum possible penalty, and so I've already explained that that could be up to 30 months in prison and a fine of $7,500, plus on the one charge, the amphetamine charge, 6 months to 5-year license suspension. However, if you are sentenced to prison on these charges, once you complete the prison term, the law does provide that the Adult Parole Authority, as part of that sentencing, could decide to exercise the option to put you under post-release control after you finish your prison term. That could be for up to 2 years, but they would make that decision. The court's not involved. And if they do, you'll be supervised by a parole officer under terms that they set. If the parole authority were to determine that you did not comply with those conditions, then they could return you to prison to make you serve an additional period of up to 9 months for a single violation, with a maximum of half of whatever prison term was imposed for all violations. That would be the cap. But if you commit a new felony while under post-release control supervision, then in addition to whatever sentence a judge in that new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control in these cases to an additional period of 1 year, whatever time is left on the period of post-release control, whichever is greater. If that occurred, that would have to be served consecutively to the sentence in the new case. Do you understand that?
I do, Your Honor.
All right, now under the law, I'm not required to sentence you to prison for these offenses. I can impose what's called community control or probation. And that means that instead of going to prison, you would be put under the supervision of a probation officer under the term set by the court. That could be for up to 5 years. If during the period of time that you're being supervised, probation department felt you were not compliant, then they would file a written notice of that alleging the violations in writing with the court. You would get a copy, and there would be a hearing. If the outcome of that hearing was that you'd failed to comply, then at that time the court could revoke your community control and sentence you to prison for a period of 30 months and fine you $7,500. Do you understand that?
I do, Your Honor.
All right, now in first case, 22 CR 147, it alleges that on or about December 2, 2021 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit methamphetamine, in violation 2925.11. So that's the charge of aggravated possession of methamphetamine, the 5th-degree felony. The other charge in 22 CR 164, the indictment alleges on or about July 7, 2022 in Highland County, Ohio, you did with purpose to deprive William C. Clough, the owner of property, knowingly obtain or exert control over said property, to wit a 2004 Chrysler Town & Country minivan, being a motor vehicle as defined in ORC 450101, without the consent of William C. Clough, the owner or person authorized to give consent. So that's the 4th-degree felony. Now, Mr. Johnson, do you understand what the state has accused you of having done in each of those offenses, what they say you did, when, where, and how they allege that you did it?
I do, Your Honor.
Have you discussed the allegations and the nature of each charge, the evidence in the case, the possible legal issues in the case, the possible defenses you could try to raise at trial, and the possible outcomes of a trial with your attorney?
That I have, Your Honor.
Are you satisfied with his advice and competence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs there at the jail?
No, Your Honor.
Has anyone threatened you to get you to plead guilty here today?
No, Your Honor.
Now, on page 2 of each indictment, there are 2 sentences that are printed in bold and underlined, and they are identical. So it reads, in each case, defendant shall enter a plea of guilty to the indictment, state defense jointly recommend community control, and that defendant be referred to drug court. Is that your understanding of the agreement, Mr. Johnson?
Yes, sir, Your Honor.
Has anyone promised you anything other than that to get you to plead guilty here today in either of these cases?
Well, rehab, other than that,
Well, drug court will include that.
Right. Then no, Your Honor.
Okay. Now, Mr. Johnson, under the law, the matter of sentence is actually up to the judge. And so even though the state, as prosecutor, saying they think you should get community control or probation and go to drug court, that still is up to the judge to decide. And I have to determine, first of all, to have you screened by the coordinator or case manager to determine if you meet the clinical criteria. And then also, I'll make a decision whether you meet the legal criteria and whether you should, whether it would appear to be the appropriate placement for you. Do you understand that?
Yes, sir, I do.
Okay. Now, Mr. Johnson, do you hold any kind of a license or certification from any state agency, a governmental agency, that regulates any profession or occupation in this state?
No, sir.
All right, now you have certain constitutional rights you must understand before I can accept your pleas of guilty. And the rights I'm going to explain to you apply in each of the two cases, whether I say that or not. First of all, you have a right to have counsel in these cases, and Mr. Wagner was appointed to represent you. Now, his appointment wasn't simply to work the case out, or the case is, but to provide any defense that might be available to you under the law that you wish to provide, if that's what you like to do. And so if you decide you don't want to do this, he will continue to represent you, including a trial in either or both cases, if that's what you want. You understand that?
Yes, Your Honor.
Right now, in each of these cases, you are entitled to have a jury trial in which 12 people would be selected from a group of citizens that live in this county that are summoned for jury duty on your trial date in each case, because there would be separate trials because of the charges are different. If you exercise that option, then the jury would be selected, 12 people would be selected from that group, the evidence would be presented, and then the court would instruct them about the law. And then in each case, that jury would have to decide by unanimous vote, meaning all 12 would have to agree, as to whether or not the state proved your guilt in either or both cases. Now, if you didn't want to have a jury trial in either or both cases, but you didn't want to plead guilty, you can waive in writing, which in the legal sense means to give up your right to have a jury trial. And then in that case, you would have what's called a court or bench trial, meaning it would be the judge would hear the evidence instead of a jury, apply the law, and decide whether or not the state proved your guilt in either or both cases. Do you understand that?
I do, Your Honor.
Right, under the Constitution, Mr. Johnson, you have a right to confront the witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is to bring out evidence that would help your side of the case in each of those cases. Do you understand that?
I do, Your Honor.
Under the Constitution, Mr. Johnson, you have a right in each case to use the power of the court to compel or force witnesses to come into court to testify for you, just like the state. So, if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order, that's a subpoena, and that would force the witnesses in that particular case to come into court to testify on your behalf if you wanted them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you in each case. Do you understand that?
I do, Your Honor.
Right now, in each of these cases, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in either case at any time. So the prosecutor could make you testify, the judge could make you testify, it's your decision. If you decide not to testify in either or both cases, the fact that you did not testify in that particular case could not be used against you in any way by any person at any time. And in fact, no one's even allowed to talk about it except in one situation. If there's a jury trial in either or both cases and you don't testify, the judge instructs that jury in that case that they cannot consider that for any purpose because it is your right. Do you understand that?
I do, Your Honor.
Now, under the Constitution, Mr. Johnson, you are presumed innocent until proven guilty by the state of Ohio on every essential element of each offense. What that means is that the burden of proof isn't on you to try to prove you're guilty of either of these charges simply because you've been accused in an indictment. In fact, under the law, you don't have to present any defense at trial. You may, but you're not required to. But whether you present any evidence in your defense in either or both cases, the burden will remain upon the state in each case to prove your guilt by proof beyond reasonable doubt on every essential element of the offense in that case, which is the highest burden of proof that's known under the law. Do you understand that?
I do, Your Honor.
All right, now, originally, you entered a plea of not guilty. Not guilty plea denied the allegations in the indictment, denied you committed any crime, and it exercised or invoked all of the rights that I've just described for you. Now, if you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea admits the allegations in the indictment, admits that they're a crime, that you committed that crime. And that plea waives, gives up all of the rights that I've just described for you today, except your right to have an attorney. You always have a right to have an attorney, no matter what your plea is, but with that exception, your plea of guilty would waive or give up your right to a jury or a court trial in each case. It would waive or give up in each case your right to confront the witnesses in open court and cross-examine them through your attorney. It would waive your right in each case to use the power of the court to compel or force witnesses to come to court to testify on your behalf in that case, the same as the state. In each case, it would waive or give up your privilege against self-incrimination because you're the one saying you're guilty, that's what would be used to find you guilty. In each case, it would waive or give up your presumption of innocence because if you plead guilty in that particular case, the state doesn't have to prove you guilty. It subjects you to being sentenced immediately by the court if the court determines that's what should happen. And finally, it waives or gives up any right to file an appeal that you think you may have had up until this point in the case. Now, if you should be sentenced to the maximum sentence or under other limited circumstances, an appeal can be filed. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
I do, Your Honor.
Mr. Johnson, are you a U.S. citizen?
Yes, I am.
Now, do you have any questions about the charge in either case or the possible penalties?
No, Your Honor.
You understand them?
I do.
Have any questions about the plea agreement in either case?
No, Your Honor.
You understand those?
That I do.
And again, you understand the recommendation on sentencing is not binding on the judge.
I understand that. I'm at your mercy, sir.
Okay. You have any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes, Your Honor.
Have any questions about the plea of guilty, what it means, or what will happen if you enter that plea here today?
No, Your Honor.
You understand that?
I do, Your Honor.
Is there anything you'd like to speak with Mr. Wagner about before we go on?
No, Your Honor. I think we've squared everything up.
You have any questions at all about anything I've explained to you here this afternoon?
No, Your Honor.
Then is it your decision, Mr. Johnson, to withdraw your not guilty plea and plead guilty to the indictments in each case pursuant to the terms of the written plea agreements that we've just gone over here this afternoon in open court?
Yes, Your Honor.
Right, then as to the charge in case number 22 CR 147, which alleges that on or about December 2, 2021, in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance to wit methamphetamine in violation of Section 2925.11 of the Ohio Revised Code. Charge of aggravated possession of methamphetamine, a fifth-degree felony, carrying a possible prison term between 6 and 12 months, fine of up to $2,500, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty, Your Honor.
Then as to case number 22 CR 167, which alleges that on or about July 7, 2022, in Highland County, Ohio, you did with purpose to deprive William C. Clough, the owner of property, not only obtain or exert control over said property to wit a 2004 Chrysler Town and Country minivan, property being motor vehicles defined in ORC Section 4501.01 without the consent of William C. Clough, the owner or person authorized to give consent in violation of Section 2913.02A1, the Ohio Revised Code, the charge of grand theft of motor vehicle, fourth-degree felony, carrying possible prison term between 6 and 18 months, fine of $5,000. How do you plead?
I plead guilty, Your Honor.
Okay, thank you. All right, the court finds on this day in open court, the defendant is advised of all of his constitutional rights, made no intelligent voluntary waiver of the same pursuant to Criminal Rule 11. Please accept an order filed. Defendant is found guilty of each offense in each case as set forth in the indictment in that case. I did neglect Mr. King, the state to consult with the victim in 22 CR 167, Mr. Clough.
Yes, Your Honor, the victim has approved of this agreement.
All right. The court then will find the defendant guilty, as I indicated, of each offense charged in the indictment in that particular case and order that to be filed. The court will refer this matter to the probation department for a pre-sentence report, which shall include an assessment for substance use disorder and or mental health issues and possible treatment. Bond will be continued. The court will set sentencing for October 5 at 9 a.m. The court does refer the matter to the drug court docket. The coordinator's out this week and won't be back, I think, till Tuesday. I don't know if the case manager will be able to get out there or not, but somebody will be out to talk with you, Mr. Johnson, and explain the program to you and decide whether you want to apply for it or not. That's something that you have to. I decided with the Get Community Control, I don't order people to go into drug court docket unless they apply for it and meet the criteria, because this is something that I'll explain to you later. Your attorney may have already, but it is it's more intensive program. There's different goals and different approaches, and so you need to understand that before we determine if you're going to be eligible to be in the program. So they'll get out there to see you, and in the event that there is a treatment bed recommended and it becomes available before the sentencing, Mr. Wagner, I would entertain a motion to release him on his OR to that facility until the sentencing is complete.
Yes, sir.
Okay, is there anything further from counsel?
No, Your Honor.
Yes, sir.
All right. Thank you.
I'm heading that way, Your Honor.
All right.
Can I talk?
approach, Your Honor?
You may. Okay.
Ms. Collins is filling out her form right now.
All right, Ms. Collins, put us on the bench mode. Bench mode, yeah.
Can I have a moment with my client?
Yeah, go ahead.
Shane.
Case number, oh, I'm sorry. At 22 CR 121. Case number 22 CR 121, State of Ohio versus Sarah Workman. Present on behalf of the state's Prosecutor Collins, Assistant Prosecutor King. On behalf of the defendant's Attorney Jacob Wagner. And are you Sarah Workman?
Yes, sir.
Ms. Workman has entered a plea of guilty, in this case, to amended count 1 and count 3, both aggravated trafficking of methamphetamine, third-degree felony. Court referred the matter for a pre-sentence investigation. I have received that report. Each of the attorneys had an opportunity to review a summary.
The state has had an opportunity, Your Honor.
Mr. Wagner?
Your Honor, I haven't. I apologize. I just got over here. If I could approach, I don't know if the court has my copy. I apologize.
Yes.
I reviewed it, sir.
All right. Anything from the state regarding sentencing?
Only what is contained in the plea agreement, Your Honor. There is restitution in this case to the task force. That would be $170, joint and several with Devontae Ames, and $180 on loan. Thank you.
Wagner?
Likewise, Your Honor. Again, this is one of the situations where hopefully the court down the road will consider, again, I know it's been recommended, treatment after a period of time of incarceration. I have spoken to Ms. Sturgill in this matter. Hopefully have a bed available for her when the court, hopefully the court will grant the judicial, Your Honor. We're trying not to delay this process whatsoever. Again, she does take responsibility for her actions. If the court would allow us, I know it says 6 months to do the judicial release. If we could file earlier than that, Your Honor, so she's about that mark after all the hearings have been set up and the court receives the pre-sentencing, which you already have, Your Honor.
Well, actually, I had to review that statute the other day. Statutorily, it has to be after 6 months incarceration. Motion can't be accepted by the court. And if I granted it, it'd be considered a nullity. And I don't know what that means other than, now, the state could appeal it, but they're not opposed to it. But in any event, it's going to have to be the 6 months. So.
I understand we'll have it ready that day.
And now she does get credit for any time served, whatever that may be, counts on that 6 months.
Yes, sir.
So that'd be 6 months in the institution, but credit for time served of 6 months after delivery to the institution.
We'll have it the day she is eligible, Your Honor.
All right. Okay, anything further? Mr.
Nothing.
Wagner? Ms. Workman, anything you'd like to say?
Yes.
Well, Ms. Workman, you didn't have much of a record. You had a little bit of a record beforehand, but it was relatively minor. This is your first felony convictions, but unfortunately, you chose to get involved really deep, really quick. The charges you were facing actually were mandatory prison terms of at least 2 years, with the possibility of those being extended by another 50%. And so, the state did give you, at least on the, I should say the first count was that. The other counts were all third-degree felonies. And you ended up pleading guilty to 2 third-degree felonies, which reduces that significantly on count 1. So at this point, whether I grant you judicial release will depend upon what happens between now and then. And so you want to make sure that you do everything you're supposed to do and not run up a bunch of tickets or other violations while you're in the institution. It is the order and judgment of the court that you be sentenced on count 1 and count 3 to a term of 24 months in each count to be served consecutively to each other. The court finds that this is a recommendation jointly from the parties. Also, the offenses are 2 separate offenses committed as part of 2 separate courses of conduct, and the harm caused is such that one single sentence would not accurately reflect the seriousness of the offense and would demean the seriousness of the crime. Furthermore, the sentences are not disproportionate to the harms caused. The court finds you have 1 day of jail time credit at this point. From May the 10th of May, you were in there for 1 day. Now, upon completion of this sentence, the adult parole authority may, at their option, if you serve the entire sentence, put you under post-release control for a period of up to 2 years under the terms they set. And if during that period of time they determine that you have failed to comply, they can return you to prison and make you serve an additional period of up to 9 months for any one violation, up to a maximum of half of your prison term for all violations. However, if you are convicted of a new felony while under post-release control, then an additional ever sentencing judge in a new case can impose upon you. The judge could also sentence you for committing that offense while under post-release control in this case to an additional period of 1 year, whatever time is left on that post-release control. Whichever is greater, if that occurs, that must be served consecutively the sentence in the new case. You're also ordered to make restitution to Highland County Task Force the amount of $170 jointly and severally with co-defendant Devontae Ames and $180 singly on a separate charge that you were convicted of. That's to be paid through the Highland County Victim Witness Restitution Escrow account, and you'll pay any fees that are charged for that service. You're also ordered to pay the court cost, for which judges grant execution's order. If you don't make payment arrangements on that, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then once you get out of prison, not while you're in prison, but once you get out, court could allow you to do community service in this county and give you credit for each hour you worked in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. All right. Is there anything further from counsel?
The mandatory fine was not
Oh,
addressed.
yeah. Are you been any change in your financial circumstances since you were arraigned and had Mr. Wagner appointed to represent you?
He's not appointed.
Yeah.
Oh, you're employed? All right.
Yes, but we're still, yes,
Okay.
not taken care of all the way, but yes, I am employed, Your Honor.
All right. Then the court will impose a mandatory fine then of $5,000 in each count. All right. Anything further from counsel?
No, Your Honor.
All right. You're remanded to custody, Ms. Workman.
Sit back, Deputy Thompson, please.
Shannon Rhodey.
May I approach?
Nay. All right, back on this case, 22-160, State of Ohio versus Shannon Lane Rhodey. We're back on record. The defendant is charged with aggravated trafficking of methamphetamine in the vicinity of a school zone and aggravated possession of methamphetamine, 3rd degree and a 5th degree felony. Matter is set for trial September the 19th. This is a final pretrial. Court has been presented with a plea of guilty form, which indicates that you're going to withdraw your not guilty plea and plead guilty to the charge of aggravated trafficking of methamphetamine in the vicinity of a school zone, a 3rd degree felony under 2925.03A1 of the revised code. The form is 3 pages long, Ms. Rhodey. On the third page, there's a sentence that says, "I enter this plea voluntarily," and underneath that, there's a signature. Appears to be Shannon Roden. Is that your signature I'm looking at here on this form?
Yes, sir.
Did you just sign this document?
Yes, Your Honor.
All right. And did you go over it with your attorney before you signed it?
Yes, Your Honor.
And did you understand when you signed it that it's an agreement to plead guilty, which means there won't be a trial, and the next step in your case will be a sentencing hearing?
Yes, Your Honor.
Okay? Deputy Thompson, you can go ahead and go. Thank you. Thanks, sir. Now, do you think you had enough time to fully consider this matter before making this decision?
Yes, sir.
You have to speak up, please.
I'm sorry. Yes, sir.
And do you feel that you were pressured or rushed in any way into doing this?
No, Your Honor.
Did you enter into the agreement to plead guilty voluntarily?
Yes, Your Honor.
Now, the agreement states that, as I said, you're going to plead guilty to that charge, and it states that you further understand that the maximum sentence on that is 36 months imprisonment. The minimum is 9 months, and then there are various levels in between those two ranges. There's a fine available of up to $10,000, a mandatory fine of $5,000, and a license suspension of 6 months to 5 years. Do you understand that?
Yes, Your Honor.
Now, I know you are currently on another case, intervention lieu, which I think has been terminated. We're pending sentencing on that. Is that correct?
It is, Your Honor.
So, in the event that you should be sentenced to prison in both of those charges, those sentences could be served consecutively, meaning one after the other, if that's what the court felt was appropriate. Do you understand that?
Yes, Your Honor.
Other than these two charges, are you facing any felony charges anywhere else?
No, Your Honor.
And other than the, again, the previous charge that you were on ILC for, are you on probation, community control, parole, or post-release control for a felony?
No, Your Honor.
Now, under the law, in each of these cases, if you are sentenced to prison, there is, as part of the sentence, the option of the adult parole authority, once you complete the prison term imposed by the judge, to require you to be put under post-release control supervision for a period of up to 2 years, which means you'll be supervised by a parole officer in the terms that they set because the court is not involved with that. And if they do that and they think you are in violation, or they find that you are in violation of those conditions, then they can return you to prison, even though you serve the entire term that was set by the court, for an additional period of up to 9 months for any single violation, up to a maximum of half of your prison term that was served for all violations. But if you commit a new felony while under post-release control, then in addition, whatever sentence the judge in the new case can impose upon you, that judge could also sentence you for committing that violation while under post-release control, in this case, to an additional period of 1 year, or whatever time is left on that period of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively to the sentence in the new case. Do you understand that?
Yes, Your Honor.
Now, under the law, I'm not required to sentence you to prison for these offenses. I can impose what's called community control, which means that instead of going to prison, you would be put under the supervision of probation officer on the term set by the court for a period of up to 5 years. If during the period of time that you were under supervision, the probation department felt that you were not complying, they would file a written allegation of that with the court. You would get a copy of it. You would have a hearing. You'd be entitled to have an attorney to represent you. And if the outcome of the hearing was that you'd failed to comply, then at that time the court could revoke your community control and then sentence you, in this case, to 36 months, fine you $10,000, and, well, that would be it. You understand that?
Yes, Your Honor.
Okay. Now, the charge in count 1 alleges that on or about November 22, 2021, in this county, you did knowingly sell or offer to sell methamphetamine, Schedule 2 controlled substance in the vicinity of the school zone, a violation of Section 2925.03A1. And that's the charge of aggravated trafficking of methamphetamine, a third-degree felony, with the penalties that I've just described. Now, do you understand what it is the state has accused you of having done, when, where, and how they allege you did it?
Yes, Your Honor.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, possible outcomes of a trial with your attorney?
Yes, Your Honor.
Are you satisfied with her advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs?
No, sir.
Has anyone threatened you to make you plead guilty here today?
No, Your Honor.
Now, on page 2, there's, toward the bottom of the page, are 4 sentences printed in bold and underlined, which read as follows. Defendant shall enter a plea of guilty to count 1. State will dismiss count 2. State and offense jointly recommend community control and star. Defendant agrees to pay back my money to the Highland County Task Force, the amount of $50. Defendant agrees to cooperate fully with the task force. Is that your understanding of the agreement?
Yes, Your Honor.
Anyone promise you anything other than that to get you to plead guilty?
No, Your Honor.
Now, under the law, the recommendation of the parties is not binding on the court, and so if you plead guilty, I'm not required to give you community control and starve. If I think that's not the right sentence, I could, in fact, end up sentencing you to prison in each of these two cases with consecutive sentences, plus fining you. You understand that?
Yes, Your Honor.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No, Your Honor.
And you have certain constitutional rights. You must understand before I can accept a guilty plea from you. First, you have a right to have counsel. Ms. Burgos is appointed to represent you not for the purpose of working a case out, but provide any defense that's available to you under the law that you would like her to provide. So, if you decide you don't want to do this, she'll continue to represent you, including trial, if that's what you want. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, Ms. Rhoda, you have a right to a jury trial in this matter in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After those 12 are selected, the evidence will be presented. They'd be instructed on the law. That jury then would have to agree by unanimous verdict, meaning all 12 would have to agree as to whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial. In that case, you would have what's called a court trial, which means that instead of a jury hearing the evidence, it would be the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt. You understand that?
Yes, Your Honor.
All right, now under the Constitution, you have a right to cross-examine the witnesses in open court. And what that means is that, and you confront them. And what that means is they have to come into court in front of you and your attorney and anyone else. And they must testify, and then after the prosecutor's done asking their questions, your attorney then has the right to cross-examine. And that means that your attorney asks questions that are designed to try to bring out evidence that might help your side of the case. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, Ms. Rhodey, you have the right to use the power of the court to compel or force witnesses to come into court to testify for you, just like the state. So, if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order, which is a subpoena that forces those people to come to court, to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. You understand that?
Yes, Your Honor.
Now, under the Constitution, you have a right to use the, you have a privilege against self-incrimination. What that means is that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. You decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to comment about it, with one exception. That is, if there's a jury trial and you don't testify, the judge instructs the jury, because that is your right, they cannot consider it for any purpose. You understand that?
Yes, Your Honor.
All right, now under the Constitution, you are presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. What that means is that you're not required to try to prove you're not guilty simply because you've been accused of this offense. In fact, under the law, you don't have to present any evidence at all in your defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio. Prove your guilt by proof beyond reasonable doubt in every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, Your Honor.
All right, now, Ms. Rhodey, originally you entered a plea of not guilty, which denied the allegations in the indictment, denied you committed any crime, and then exercised or invoked all of the rights that I've just described for you. Now, if you change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea admits the allegations in the indictment, admits that they're a crime, that you committed that crime. And that plea waives, gives up all the rights that I've just described for you, except one, your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty waives, gives up your right to a jury or court trial. Waives, gives up your right to confront witnesses against you and cross-examine them through your attorney. Waives, gives up your right to use the power of the court to compel or force witnesses to come to court to testify for you, the same as the state. It waives, gives up your right to, or your privilege against self-incrimination, because you're saying you're guilty, that's what's used to find you guilty. It waives, gives up your presumption of innocence, because if you say you're guilty, the state's not required to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives, gives up any right to file an appeal that you think you may have had prior to this point of the case. Now, should you be sentenced to the maximum sentence or under the certain limited circumstances, you could file an appeal, which would have to be filed within 30 days of your sentencing entry being filed. Do you understand all that?
Yes, Your Honor.
And, Ms. Rhodey, are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about the charge or the possible penalty?
No, Your Honor.
You understand it?
Yes.
Have any questions about the plea agreement?
No, sir.
You understand it?
Yes.
And again, you understand the recommendation on sentencing is not binding on the court.
Yes, sir.
You have any questions about the constitutional rights I've explained to you?
No, Your Honor.
You need to keep your voice up.
No, Your Honor.
All right, you understand them?
Yes, I do.
You have any questions about the plea of guilty, what it means, or what the consequences of that will be if you enter it here today?
No, Your Honor.
You understand that?
Yes, sir.
Is there anything you'd like to speak with Ms. Barger about before we go any further?
No, Your Honor.
Have any questions about anything that I've explained to you here today?
No, Your Honor.
Then is it your decision to withdraw your not guilty plea, plead guilty to the charge in count 1 as set forth in this plea agreement?
Yes, Your Honor.
Then as to the charge which alleges in count 1 that on or about November 22, 2021 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance in the vicinity of a school zone in violation of Section 2925.03A1 of the Ohio Revised Code, a third-degree felony, aggravated trafficking of methamphetamine in the vicinity of a school zone, carrying possible penalty of between 9 and 36 months in the increments provided by law, fine of $10,000, a mandatory fine of $5,000, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty, Your Honor.
All right, thank you. You may be seated. The court finds that the defendant on this date in open court was advised of all of her constitutional rights and made no intelligent voluntary waiver of the same pursuant to Criminal Rule 11. Please accept it or file. The court finds the defendant guilty. Now, we are already in the process of a pre-sentence report. When's our sentencing on the other case? Do you have?
We don't have one. There's
Don't have
not
one
one
yet.
currently set, Your Honor.
Yeah.
You're waiting to see what happened with this case.
All right. All right, so we'll go ahead and set sentencing for October, I believe that's 5th at 9 a.m. October 5. Bond to be continued. There's a star referral as well. And you see Mr. Arjun over here to decide when you're going to be reporting for your pre-sentence report. For your pre-sentence interview, I should say. You continue to report. I notice you've been testing positive for THC, marijuana, and a lot of people think because we have medical marijuana in the state that means it's can be done when you're on community control. It doesn't mean that at all. It was specifically part of your intervention conditions you not use any controlled substance. Now that you have been found to be in violation of that, but continuing to use that will not help your case. So you need to get off of it. I know a lot of people think it has medicinal properties. I think I guess the legal term for that would be BS, in my opinion, because scientific evidence is absolutely non-existent as to that, and every person that's in the treatment field will tell you that it is harmful to people that are in recovery, not helpful. So I want to see negatives on that on your report. I hope you have negatives because that will have some impact on my decision. All right. See the probation officer. You get your assignment notice from the bailiff. Thank you.
Thank you, Your Honor.
Sierra Wilson. Case number 22-0155, State of Ohio versus Teresa Ann Sharp, present for the state, Prosecuting Attorney Collins and Assistant Prosecutor King. Present for the defendant's attorney, Jacob Wagner. Are you Teresa Ann Sharp?
Yes, sir.
All right, Ms. Sharp's charged with 3 co-defendants in an indictment, joint indictment, 16 counts. She's charging counts 5 through 16. This is a final pretrial. The trial is set for September the 26th. All right. Is discovery complete on this, counsel?
It is from the state, Your Honor.
I believe so, Your Honor.
There are no pretrial motions?
Not pertaining to the evidence, Your Honor.
Okay, what does that mean?
Well, Your Honor, if I may, not to answer your question directly, my client was OR'd around the 4th of August of this month, but she had to hold her out of Montgomery County. So they came and got her out of Montgomery County. She wasn't released there until the 18th. So when she got back here, and I've already yelled at her, she did call my office, but we didn't have a good working number. I don't think she's checked in with probation. We do have an offer from the state that I believe is going to be accepted. I just need to go over with it and explain drug court to her, Your Honor. So I guess my question, if the court would grant us, because we're set for the 26th, a week, or vacate that and set it for a plea date, Your Honor, or probably within the 2-week plea time, I don't know. I'm gone all next week. I just don't want to go against this court's rules, Your Honor.
All right,
She's
well,
fine with the continuance.
let's do this. Let's go ahead and set it for trial, for a plea on, I've got to get the calendar. Probably on the 19th. And if there's not a resolution, we'll continue it for like 2 weeks, 3 weeks, but there will be a trial.
Yeah, I'll be back, obviously, by then, so I'll just give them, I got her good number now.
All right. Need the calendar, Ben.
The 19th is a trial day.
Oh, it is?
Yes.
Then we'll have to continue the trial. All right.
No, I'm sorry, not her trial day, it's just a trial day. We have-
Yeah, I think everything's off now. Isn't it?
No, it's not.
19th,
No.
oh, yeah. Let's see.
Her trial day is the 26th.
Well, we're having pre-trials next week, right? Yeah,
We are.
because we still have, well, Mr. Anderson has been moved. So we still have Nicely, which is your case.
That was pled.
That
Was
pled,
it
Your
pled?
Honor.
All right. Holsinger, which is Kirk.
No, Holsinger now is somebody else, and she filed a motion to continue.
Okay.
An out-of-town attorney.
Yoakum, which is Hapner, but didn't we continue that for a polygraph?
That's now on the 26th.
Okay.
But she has a pretrial in one case on the 19th. for
Who
some
does?
reason. Yoko.
Okay.
And the jury trial.
What about Holsinger? Oh, you think it's been continued?
It has not yet, but I know a continuance was filed by the new attorney.
Oh, okay.
It was filed the day before yesterday, I think.
All right. Bolton House.
That's set.
Lunsford Jr. is yours?
Who?
Lunsford Jr., Charles Lunsford
That's
Jr.
pled.
Pled. Christina Gill pled. Stephen Walker. That's Mr. Kirk.
Who?
Stephen Walker.
I think that pled.
Devin Sparks and Josh Framuth, he just pled.
So,
And
We
Mr.
should-
Sparks, I know I just issued a warrant for him yesterday out of domestic relations court. So I don't know. I did set a pretrial for him to come in next Wednesday. So we have, you think Walker's pled?
I think so. Our calendar shows that we have Sparks, Bolton House, and Holsinger still on the docket for the 19th for
All right.
trial.
Sparks, Bolton House, and Holsinger.
Yes.
All right. Well, I'm trying to remember if I saw that motion yet. Because I,
Oh, Your Honor, Devin Sparks is in our jail.
oh, yes.
Yeah.
Oh, okay. How'd that happen?
Apparently got arrested.
Oh, maybe he got arrested on our warrant.
Maybe.
Okay. Well, tell the magistrate.
The arrest date says July 19th.
He's been in since July 19th.
Oh, okay. I thought somebody said he was out on bail. Okay.
He was out on bail at one time. I don't know.
All right. Okay. So we have all those three scheduled for pretrial next Wednesday. So let's put this down. Actually, here. Yeah, Yoakum is set for 2 o'clock pretrial that day in anticipation of the resolution of the case because of the polygraph. So let's go ahead and set this one at 2:30.
Well, what they serve.
The 19th. And I'll go ahead and grant your continuance to continue the trial date to But in saying that, what I'm gonna say is this, there'll be a plea on the 19th or a trial on the 24th. I'm not gonna extend it, the time to work a deal out. We've had enough time to do that. So,
Yes, sir. I anticipate the 19th, the resolution, sir.
so get a assignment notice from the bailiff, Ms. Sharp, and then see the probation officer. And I don't know if you need to report down there what you've got going, but he can give you an update, whatever you need to do. All right, anything further, council?
No, sir.
All right, thank you.
Thank you, Your Honor.
This is case number 21 CV 210, State of Ohio versus Russell Burchett II and unknown tenants at 9071 Water Street. And you are Russell Burchett II?
Yes.
All right. The plaintiff is represented by Prosecutor Collins and Assistant Prosecutor King. This is a complaint for injunctive relief to enjoin the accumulation of solid waste and to order it to be cleaned up. This is the trial date, I believe. I know we had to be extended a couple of times to get service, and then there was a continuance granted, back in May because service had not been completed. And so service was just completed by personal service. Well, no, that was a return of service. Looks like it was completed on June the 19th, personally by Deputy Hughes. And then motion was filed for default judgment. Now, Mr. Burchett, the notice or the service that you received indicated that you had 28 days to file an answer, and you did not file any answer. And so the plaintiff filed a motion for default judgment. Under the law, what that means is that when somebody doesn't file a response and defend against the case, then the party that filed the case can get judgment by default because there's been no defense offered. And now what the extent of that judgment will be is still up to determination by the court. But because you have not answered, under the law, you're deemed to have admitted that everything they said was correct. And so the only issue before the court is to order a cleanup and a certain period of time for you to accomplish that. Now, has there been any change in circumstances of the property recently?
No, Your Honor, there's still quite a bit of cleanup to do.
All right. Now, I believe there were quite a few pictures. I'll go again. Really wish somebody in the prosecutor's office or health department would invest in a color copier. It's really hard to get pictures.
I do have color photos if you would
Yeah.
like.
Or a color printer and just email them and print off multiple copies, as these are hard to see, but I can see there's a good bit of stuff accumulated on the property. Mr. Burchett, is this a rental property?
No, it was my shop, and the reason all this stuff is there, my mom actually sold the farm and we moved everything over there in a big hurry.
This is down in Sinking Spring, isn't it?
No, Carmel.
It's
Oh,
in,
Carmel.
it's in New
We live
Petersburg.
in Carmel.
Where?
It's in New Petersburg. It's the old
The old
school in New
school.
Petersburg.
Oh, New Petersburg, okay.
That's the old school.
Because there's a whole bunch of water streets around the county.
Yes.
Yeah, this is in New Petersburg,
Yes.
down by the old school?
This is the old school.
Oh, it is the
Yes,
old school?
yes.
Okay, I'm sorry, go ahead.
Well, I mean, as far as like, I don't know, like all the tires and stuff like that, I mean, no, they don't, but I mean, and the brush. I also seen in there, it said something you couldn't burn brush. Is that correct?
Well, this is the law that bans open burning and open dumping.
Okay, but as
I
far
don't
as
think the
like,
complaint is burning, is it? It's the accumulation of solid waste, isn't it?
Correct, Your Honor.
Right.
as far, I mean, yeah, I mean, and I am working, I don't know how recently you've been out there, but, all the, trustee, and then there was a vehicle parked too close to the road, and I pushed it going off the road. And, I mean, no, I don't want it to look that way either. I mean, but as far as like the tires, it's off rims, I got them all picked up.
Well, what I'm going to do, see, today is September the 1st, so we want to see this cleaned up before the snow flies. But what I'm going to do is give you 60 days, that would be November the 1st, to clean this up.
Okay,
Now, so the court orders that the nuisance be abated at 9071 Water Street, Hillsborough, Ohio, aka Petersburg, and that the defendant remove those items and cease to accumulate or store any items in the future. under penalty of contempt. Now, you'll need to communicate with the health department so that will keep them aware of what you're doing. You'll need to, everything that you dispose of has to be disposed of in accordance with the law. And so that doesn't mean you pick up tires and other trash and take it somewhere else and dump it.
That's right.
It has to be disposed of properly. So if they're tires, they got to be taken to a appropriate recycling center or stored in an acceptable facility that complies with the law. If you have any questions about what that is, you can talk with the health department and they will advise you of that. In the event that you don't comply with these, this order, Mr. Burchett, is an injunction, and if you don't comply with it, then the plaintiff could ask the court to hold you in contempt, and on your first offense, it would be subject to being 30 days in jail and a $250 fine, and each subsequent offense continues to increase. So, make sure that you get on this as quickly as possible, but in no case any later than November the 1st. And, the ownership of property requires that it not be maintained in such a way as to violate health and waste laws. And, I know they say one man's junk is another man's treasure, but unfortunately, when you just leave it all out there and it's not a business in terms of a retail business or something, or an antique store or something like that, then you're subject to these laws. You have any questions?
Can I get a picture of what you,
Yeah, they can show you everything you've got after we're done here. So just talk with them. They'll work with you. You just need to keep in communication with them. But, this thing's been going on for a while, since May or June when you were served. So, you need to get on it. All right? Thank you.
Please rise.